Although it may seem as though abortion is a more recently discovered procedure because of the medical knowledge and technology needed to perform it, it has been practiced since long before the 1800s. Medicine has certainly improved since these times, but the idea and implementation of an abortion has been present for well over a century. Though it was performed and legal, the lack of medical technology made having an abortion very risky. Abortion may have started off legal, but by about 1880, many states in the US had decided to invoke anti-abortion legislation in order to fight against the recent progress of women's rights of suffrage and birth control. Around this time was the eugenics movement, and the US government was concerned about race suicide, fearing that the incoming immigrants and their higher birth rates would dominate the population. They figured that prohibiting abortion would result in a rise in the number of white, native children born, which would combat the increase in people of other races entering the US. Doctors were also a key factor in criminalizing abortions. They had the American Medical Association argue that abortion was dangerous and immoral in order to secure for themselves exclusive rights to practice medicine. By the year 1910, 49 out of the 50 states outlawed abortion under all circumstances except where necessary. When the legislation was enacted, abortions did not simply come to a halt. Instead, women desperate for an abortion would find ways around the law. It has been recorded that in the years before criminal abortion laws were repealed, as many as 1.2 million women had illegal abortions, many of whom suffered serious medical problems as a result of unsanitary conditions or rudimentary methods. Fast forward a century and abortions become legalized with the Supreme Court ruling in the case of Roe v. Wade. This case consisted of a woman named Norma McCorvey, who the courts referred to as Jane Roe, who discovered she was pregnant with a third child. She returned to Texas and falsely reported that she had been raped in order to obtain a legal abortion. When her plan failed because there was no police report of said rape, she attempted to receive an illegal abortion. This scheme also failed as she found that the unauthorized facility had been shut down by police. So, she decided to hire attorneys and argue before the courts that the right to privacy stated in the Constitution included the right for a woman to decide whether or not to have a child without state interference. Her case, fought against by Texas Attorney General Henry Wade, made it all the way to the Supreme Court, who, after much deliberation, ruled 7-2 in favor of Norma McCorvey. Since then, there has still been controversy over the subject of abortion, and the Supreme Court has permitted more regulation and restriction on them. In 1992, Planned Parenthood v. Casey resulted in the ruling that abortion is legal before fetal viability, but the states have the power to deny access to them as long as their restriction does not have an undue burden on women that are looking to have an abortion. At one point in 2003, Congress passed a federal ban on abortion procedures that was then signed into law by Bush. Luckily, the National Abortion Federation was able to successfully block its enforcement. However, the Planned Parenthood v. Casey ruling has led to regulations we are seeing even today.
Since 2010, new state laws have contributed to the closure of about 70 abortion clinics, and these 4 states are down to exactly 1 abortion clinic each. That's right, Mississippi now has 4 times as many S's as it has abortion clinics. And if you're thinking, how is that possible? Well, it's in no small part because the key Supreme Court decision concerning abortion is no longer Roe versus Wade. It's the 1992 Planned Parenthood versus Casey ruling that said states can create restrictions as long as they don't place an undue burden that places a substantial obstacle in the path of a woman seeking an abortion. Meaning women can be asked to jump through a few hoops, just not too many, which might sound a little less insulting if those weren't also the rules for a dog agility course. And the vagueness of that ruling has allowed states to introduce dozens of what some have called trap laws, or targeted regulation of abortion providers.
Regardless of the restrictions put in place, people still share very different views when it comes to the right of an abortion. Typically, young people are seen as pro-choice, with older generations stigmatized as strong supporters of pro-life. Though this may apply to some people within those generations, surveys over the recent years have shown surprising data. When abortion was legalized in the 1970s, there was a significant difference in the way young adults felt compared to the older generation. While seniors were much more conservative in their views on the issue of abortion and generally disappointed with the court's ruling, younger Americans were much more liberal and supportive of the decision. However, recent surveys have exhibited that generational differences have been blurring in regards to their opinions on legal abortion under all circumstances. Rather than there being a large gap in views between the generations, young adults ages 18 to 29 have become less supportive of abortion under any circumstance and have therefore brought themselves closer to the opinions of adults between the ages of 30 and 64. In other words, the information gathered has shown that more young adults between ages 18 and 29 believe that abortion should be illegal, at least in some circumstances. As of 2010, it has been identified that more seniors of age 65 and up are open to legalizing some situations of abortion, although they are still more conservative than younger generations. So while it may have been logical to believe that a younger generation would be significantly more liberal and pro-choice, the reality is that their current views are similar to those of older generations, as many are becoming supporters of having a more pro-life perspective.